Richards.
Before I turn to the cases of Savage and Raybone, can I just come back to two matters from this morning? The court asked if there was any reference in the Strasbourg authorities to, in the context of the systemic duty, to administrative as well as regulatory frameworks. And if I can simply give you the references. In the case of Honour Yildiz, which begins at page 5157, the reference to administrative frameworks is in paragraphs 89 and 91 on page 5185. And then secondly, the case of Budayeva, which starts on page 4457, the relevant paragraph is paragraph 138 on page 4478.
4478. Thank you very much.
The second point was in relation to my Lord's and my Lady's question about the how the Mental Capacity Act in practice works in terms of decision making. Rather than take time up with that now by way of me attempting to give an explanation, because the Act itself really just gives the bare bones, there is a decision in a case which is not in the bundle called N and a CCG, which may help. Alternatively, an extract from the Code of Practice under the MCA may help. And so I propose this evening, once we finish the day, I'll look and see if there are materials that would assist in answering the question directly, obviously provide them to Mr. Beer overnight.
Yes, there must be a legal provision somewhere which tells you who can take decisions on behalf of an adult who lacks capacity.
Yes, and there are. Effectively, in a sentence, it's the person or people or bodies who are engaged in relation to the particular subject matter of the decision. So it might be a family member giving personal care who takes the decision that it's in the best interest to give personal care. It might be a care worker if it's personal care. It might be a doctor if it's a specific form of medical treatment. But either the code or the authority that I'm thinking of, I think, will answer that question more neatly. If I can then turn to the first of the two principal domestic authorities, the case of Savage. It starts on page 2463, but if the court could go to page 2476. You will see the discussion that begins in the judgment of Lord Roger, paragraph 18, under the heading The Positive Obligations to Protect Life. Savage was a case of a patient, psychiatric patient. She was detained under the Mental Health Act. So she was deprived of her liberty under the statutory framework of that Act. It was a suicide case. She left the grounds of the hospital and threw herself in front of a train. So that's the factual context in which the question arose. Was there an operational obligation, an Osmond Keenan operation, to prevent that? No Strasbourg authority had looked at the position of detained psychiatric patients at that point in time. There'd been the prison cases, the conscript cases, the administrative detention cases, but no psychiatric patient cases. So that matter came before the domestic courts, in this case, before it had been considered by the courts in Strasbourg. There is then a detailed discussion by Lord Roger, and I'm going to refer you to paragraphs, but it's really a judgment that needs to be read in full, which goes through the various different aspects, as understood at that point in time, of the Article 2 obligation. So we have...
Presumably the substantive obligation, because he says at the end of paragraph 17 that he's not dealing with the procedural obligation.
Yes, that's absolutely right. So the case of Savage was nothing to do with inquests, nothing to do with the procedural obligation. It came before the court because Mrs. Savage's family had brought a claim in damages and for declaratory relief in relation to Article 2, and there had been an application by the Hospital Trust to strike that out. So it was effectively the preliminary issue was the duty owed to someone in Mrs. Savage's position. The House of Lords answered that question, yes, and the case came back for a trial in due course before Mr. Justice Mackay, in which he found that there was, as a matter of fact, a breach of Article 2. So that was how the issue arose, so not concerned with the procedural obligation at all in Savage. And then if we Your Lordships will see, your Ladyship will see, paragraph 19 on page 2476 identifies the high-level duty, and then express reference to Osman, and we see the Osman formulation between G and H on that page. There's then reference to in the discussion of the LCB case, which is worth reading, but I won't take time with it now, but perhaps just invite the Court's attention on page 2477 to the last sentence of paragraph 22, so between G and H, where having made some observations about LCB, Lord Rogers said it's worth noticing, however, that the decision in the LCB case suggests that if triggered, the duty would have applied to the medical authorities just as much to any other public authorities. There's then a discussion of Osman. I don't propose to ask you to read through that. If we go over the page to 2478, there is the heading towards the bottom of the page, duty to protect against suicide prisoners. And in paragraph 25, the point made is similar to the point I made this morning, that there isn't a general obligation to prevent suicide. And then paragraph 26, page 2479, Lord Rogers says this: nevertheless, the European Court has recognised that in certain circumstances, the state's duty under Article 2 does indeed include a duty to take steps to prevent people from killing themselves. And then we have reference to Keenan, and then paragraph 27, Lord Rogers says, essentially asks the question, what's the basis for this, given that there's no general duty to prevent suicide in the population? And just above letter D, the Court found the requisite basis in its previous very brief holding in Salman and Turkey that persons in custody are in a vulnerable position and the authorities are under a duty to protect them. So that's the jurisprudential basis. Bottom of the page refers to that as vulnerability essentially as a statement of the obvious. That's paragraph 28. If the Court then goes over the page, I just draw attention to paragraph 30 next on page 2480. Because it may help in cast some further light on some of the discussion this morning. You'll see in paragraph 30, first of all, reference to a high-level general duty, and then 5 lines down, Lord Rogers says, more relevantly, there is a lower level, but still general duty on a state to take appropriate measures to secure the health and well-being of patients.
Prisoners.
Oh, I'm so sorry, my lady, of prisoners. And then there's reference specifically to the risk of suicide between F and G, and reference to various cases.
Just in paragraph 30, Lord Roger is referring to the arrangements that are made with the National Health Service as well.
Yes.
So presumably, sometimes if a prisoner is feeling particularly unwell, there has to be coordination with the National Health Service, is that right?
Yes, as we saw in the Russian context in Turarieva. And then paragraph 31, again, this is really just to try and understand the way in which the House of Lords viewed the interrelationship between the nature of the general duty and then its interrelationship with other duties. Paragraph 31, if the authorities fail to put in place appropriate general measures to prevent suicides amongst the prisoners in a particular prison, and as a result a prisoner was able to commit suicide, there would be a breach of Article 2, and that's a breach of the general or systemic duty that he's talking about there. And then he goes on to say, if, on the other hand, the authorities had employed properly trained staff, taken all the relevant general precautions, but a prisoner nonetheless succeeded in committing suicide because of the casual negligence of the prison staff, the prison authorities would be vicariously liable for that negligence, but there'd be no violation of Article 2. And then he goes on to talk about, and that's again in relation to the systemic or general duty, and then he goes on to talk about the more stringent measures that might be required in relation to the operational duty, and we see that by reference to Keenan in paragraph 32, where, and picking it up at D, even if the authorities had fulfilled all their other obligations, their failure to fulfil this obligation would have been liable to result in a violation of Article 2. The influence of Osman's case is plain. Then we have the heading duty to protect other detainees, reference to the Slimani case, immigration detention. I don't, again, propose to read that out, but we've made reference to that. And then over the page, so page 2482, towards the top of the page before paragraph 34, we have the heading duty to protect against suicide conscripts. Again, I won't read through the detail of it, but Lord Roger refers to the Killinch and Turkey case in paragraph 35, the references to which are in our case. And then in paragraph 38 on the next page to the Appellant and Turkey case, which I took you to this morning, where Lord Roger observes, and this is at letter C on page 2483, in Appellant and Turkey, the court held that this operational obligation would indeed apply in the case of conscripts. We then have the heading, the nature of the duties, and there's a discussion in paragraph 39 about the factors that might be influential depending on the context. So just below the letter F, position of vulnerability of prisoners is stressed, the human reaction to being called up to do military service mentioned in the case of conscripts. Paragraph 40 then refers to framework, and here's another reference, in fact, to the administrative framework in the opening sentence of paragraph 40, and then reference to general practical precautions that may be required, just alongside letter G. If we then go over the page, we then see a discussion of the operational duty. I don't propose to read through paragraphs 41 and 42, but then paragraph 43, Lord Roger says, I turn to the position in the present case, so an individual detained under section 3 of the Mental Health Act, and he poses the question, last sentence of paragraph 43, what obligations does Article 2 impose on the state authorities in such case, in such a case? There's then a discussion of the then state of the case law in relation to the general duties. Perhaps instructive to note a reference to terra arieva just below letter H. And then if we go to page 2485, paragraph 46, but just above is the heading, the duty to protect the lives of patients suffering from mental illness, and reference there again to vulnerability, so the vulnerability of persons suffering from mental illness and the consequent need to protect them are themes that run through the case law of the European Court. And then paragraph 47, Lord Roger says there's nothing new in this. And then paragraph 48, if it turns out the hospital authorities have not had in place appropriate systems, so here he's looking at the general duty, say for preventing patients who are known to be suffering from mental illness from committing suicide, not only would the authorities be potentially liable under domestic law for any resulting suicide, but they would have also violated one of their positive obligations under Article 2 to protect their patients' lives. And then if we go over the page, we have the heading, the duty to protect detained patients' lives. So this is page 2486. And having already referred to vulnerability in the context of Mrs. Savage, here we see detention as another relevant circumstance. The fact that Mrs. Savage was not only a patient but a detained patient is also relevant to the authorities' obligations under Article 2. Any auction in the comparative vulnerability of prisoners, voluntary patients and detained patients would be as unedifying as it's unnecessary. Plainly, patients who've been detained because their health or safety demands they should receive treatment in the hospital are vulnerable. Vulnerable not only by reason of their illness, which may affect their ability to look after themselves, but also because they are under the control of the hospital authorities. And then skipping to the sentence, mutatis mutandis, the principles in the case law which the European Court has developed for prisoners and administrative detainees must apply to patients who are detained. And then paragraph 50, there is then a discussion, again, of the general obligation to prevent suicides. The Lord Roger says he's satisfied that as a public authority, the Trust was under a general obligation by virtue of Article 2 to take precautions to prevent suicides among detained patients in Runwell Hospital. And then examples had to employ competent staff, take steps to see that they were appropriately trained, and so on. And then if we go to the next page, we see the dispute in this case. Again, I just flag up, he sets out the rival submissions, which we don't need to look at. There's a discussion in relation to terra arieva in paragraphs 53 and 54. And then if we turn to, that's page 2489. Bottom of the page, paragraph 65, neither Powell's case nor Dodov's case provides any basis whatever for the proposition that as a matter of principle, medical staff at a mental hospital can never be subject to an operational duty under Article 2 to take steps to prevent a detained patient from committing suicide, even if they know or ought to have known there's a real and immediate risk of her doing so. The obvious response to that proposition is, why ever not? What else would they be supposed to do? Article 2 imposes on the hospital authorities and their staff an obligation to adopt a framework of general measures to protect detained patients from the risk of suicide. Why should they not be under the usual complementary operational obligation to try to prevent a particular suicide in the appropriate circumstances? And then paragraph 66 identifies the counter-argument and rejects it. And then the last sentence of paragraph 66, in my view, it is abundantly clear that where there is a real and immediate risk of a patient committing suicide, Article 2 imposes an operational obligation on the medical authorities to do all that can reasonably be expected of them to prevent it. So that's the extension or application of the operational obligation principles in the context of detained psychiatric patients. The next iteration in the development and application of the operational obligation, but here domestically rather than in Strasbourg.
And Lord Roger does seem to be operating a fairly clear distinction between the systemic duty and the operational duty.
Certainly as a matter of principle, whether it's always easy as a matter of fact to ascertain whether something falls within one or the other may be more difficult to answer. But I accept that he is identifying them in principle as distinct obligations.
So what is the principle you wish us to draw out of this case as to the circumstances in which the operational duty arises?
That the operational duty was held to arise here effectively on the grounds of vulnerability and detention. Those were the factors which led to the court's conclusion. A logical and uncontroversial application, effectively, of the principles that have already been identified in Strasbourg.
Well, but don't you need the real and immediate risk? Looking at the end of paragraph 66, Lord Roger is conditioning the duty in fairly classic Osmond terms, isn't
Yes, absolutely. That was the position in Savage. We'll see it's also the position in Raybone. The domestic courts, when looking at the operational obligation and their application to patients, have applied the same formulation as the European Court did in Osmond, Keenan and Edwards, the real and immediate risk, absolutely. There is a... What
do you say is the relationship between knowledge of real and immediate risk and the vulnerability and detention?
The operational obligation, duty to take protective measures to mitigate that real and immediate risk, has been held to arise not as a general obligation whenever there's a real and immediate risk to life, but an obligation in particular contexts. And the context in which it has been identified by the European courts and the domestic courts have focused on contexts in which a person is detained and thus in the control of the state, and or contexts where a person is particularly vulnerable.
Right, but
therefore, the protective obligation is owed.
Is it that someone is detained and or vulnerable that in some way, I'm not sure, decreases the Osmond threshold?
No.
So is it that if they're detained and or vulnerable, that there's more means of knowledge to the state to inform whether they are or should be aware that there's a real and immediate risk of death?
Well, the starting point in my submission is that there is a protective duty owed by the state to those who it has detained or over whom it exercises control or for whom it's assumed responsibility. So there is that protective obligation. recognising, as the courts do, that they're going all the way back to Osman, that there is there should not be a disproportionate burden imposed upon public authorities. The duty is triggered by the existence of the real and immediate risk to life.
So it's triggered by?
By the existence of the real and immediate risk to life, and either actual or constructive knowledge of that risk.
But as you said, I think at the outset, there are lots of people who are not detained, not within the care of the state, whom the state may come to know is at a real and immediate risk of suicide, but the state has no duty to stop them from committing suicide. It's only because the person is in their care that duty arises.
That's certainly the principal thrust of the case law. There is one case, whether it's an outlier or not, maybe a matter for debate. It's called something like Mamadov. It's referred to in one of the authorities, and again I'll find the reference in the course of either in the afternoon or overnight, in which it was someone who was not in the care of the state, but who, for whom, in respect of whom it was identified that the public authorities should have had knowledge of a real and immediate risk of suicide. If I've remembered the facts...
Somebody is on a window ledge outside a building, threatening to jump. The police may be called, the police may try and persuade them to come down. All sorts of state bodies may get involved trying to persuade them not to do it. But if they do then do it and die, that isn't a breach of the state's Article 2 obligations.
My lady, I agree. The only reason I've referred to the case, as I say, I think it's Mamadov. It wasn't someone who was detained or in the care of the state, but there was still a nexus between the individual and the public authorities. If I've remembered right, and I will have to check this, it was in the context of an eviction. So there was something that brought the public authorities and the individual into direct communication. But the other suicide cases, if I can put it that way, and the other healthcare cases where the operational obligation have been held to arise, have been where there is this relationship between the state and the individual through deprivation of liberty or some other form of assumption of responsibility and knowledge of vulnerability. And I'm certainly not arguing for some kind of freestanding, much broader obligation in the present case. So, my Lords, my Lady, just invite you to note there's a concurring judgment from Baroness Hale, which starts on page 2491. Again, I won't go through it, but I invite the court to read it. But if I could just flag up page 2495. Paragraphs 85 and 86, where you will see that at least Baroness Hale at least reads that both the Slimani and Tararayeva as operational obligation cases. The paragraph 85, she says, the Osmond principle has been extended to the healthcare given to prisoners and other detainees, reference to Slimani, and then reference in paragraph 86 to Tararayeva. And then, just over the page, in fact, I don't think I need to refer you to any other particular matter, part of the judgment of Baroness Hale. It's effectively in agreement with the judgment of Lord Roger. That obviously was the position of a detained patient. The position of a patient who is mentally unwell, but a voluntary patient in a psychiatric hospital, then came before this court in the case of Raybone. And so if the court would go, please, to page 2420.
So just at the end of paragraph 86, Lady Hale recognises Tararayeva as an example of a court examining individual operational failings and not simply whether there were proper systems in place. And the question that arises for us really is, would it do that in any case of a prisoner or indeed other categories of vulnerable person? Or was there something about the particular facts there that explains the approach adopted?
Well, I would respectfully submit that there's nothing in the facts of Tararayeva to suggest that it's an exceptional or unusual case on its facts that's attracting the application of those principles.
Yeah.
So if we turn to Rayburn, which starts on page 2420, and so again, the factual context, not a case concerning the procedural obligation, a case concerning the substantive obligation alone. A claim had been brought by Ms Rayburn's parents under the Human Rights Act, this was the culmination of that claim. If we pick it up, and I should just say, in relation to the facts, Ms Rayburn, voluntary inpatient, assessed as able to go on home leave. The failings in the Rayburn case effectively were inadequate assessment by the psychiatrist of the risks that were posed and no proper planning for her care while she was on the weekend home leave. And those were found to constitute a breach of the operational obligation. She hung herself from a tree in the local park whilst on that period of brief home leave. The discussion of Article 2 starts on page 2431. It's the judgment of Lord Dyson. I don't, again, intend to read through it, but if I can perhaps just highlight particular paragraphs. So paragraph 12 sets out some introductory comments, refers to Honour Yildiz and the case of Osman, and identifies the operational duty at letter F on page 2431. And then if we go over the page to page 2432, at letter E, there is the heading, the first issue: can an operational duty under Article 2 be owed to a hospital patient who is mentally ill but is not detained under the Mental Health Act? And then again, there are references and a discussion of various authorities, which I won't read through, but we can see in paragraph 15, Edwards, Keenan, Slimani, the Savage case, which we've just looked at, and the position in relation to conscripts. And then Lord Dyson discusses the physical dangers cases on a Yildiz. And then, my lady, paragraph 17 is the case I was thinking of. Mammadov and Azerbaijan. That was where someone set fire to themselves during an attempt to evict the applicant and family from accommodation that they were occupying. And you'll see what's set out in to D. In a situation where an individual threatens to take his or her own life in plain view of state agents, and moreover where this threat is an emotional reaction directly induced by the state agent's actions or demands, that's the trigger in that case. But it is, as far as I can recall, the only case which arises outside of the kind of context with which we're discussing. Paragraph 18, Watson, the United Kingdom care home case. And you'll see the summary in Lord Dyson's judgment, third line of paragraph 18. The court held that a badly managed transfer of elderly residents of a care home could well have a negative impact on their life expectancy. Followed that Article 2 was applicable. The operational duty was therefore capable of being owed in such circumstances, but for various reasons the claim failed on the facts. There's then a discussion of the line of authorities which had been considered by Lord Roger in the Savage case. I won't go through those. But if we turn to paragraph 21 on page 2434. Lord Dyson says this: it's therefore necessary to attempt to discover the essential features of the cases where Strasbourg has so far recognised the existence of an operational duty. It is clear that the existence of a real and immediate risk to life is a necessary but not sufficient condition for the existence of a duty.
Do you accept that that applies equally in this case?
yes, with one qualification, which is, as we set out in the written case, there is this line of authorities, Terrarieva, and then a range of other authorities, where the obligation to those who are deprived of their liberties appears to be viewed through the prism, as we discussed this morning, of a failure to give adequate care and treatment. And whether that really is the Strasbourg Court trying to do something different is an interesting point, and one which may not be easy to answer. Our primary case has always been the real and immediate risk line of authorities, that Raybone covers the present context as much as it covered the context that it was considering. But I will come back to that secondary line of authorities briefly in the course of the afternoon. So paragraph 22, Lord Dyson refers that there's no decision where the court clearly articulates the criteria by which it decides whether an Article 2 operational duty exists, and therefore says we have to look at the case law. And then if we can see, picking it up towards the bottom of that page, the operational duty will be held to exist where there's been an assumption of responsibility by the state for the individual's welfare and safety, including by the exercise of control. The paradigm example of assumption of responsibility is where the state has detained an individual, whether in prison, in a psychiatric hospital, in an immigration detention centre, or otherwise. The operational obligations apply to all detainees, but are particularly stringent in relation to those who are especially vulnerable by reason of their physical or mental condition. Keenan, mental, Terrarieva, physical. So Lord Dyson appears to view Terrarieva as a manifestation of the operational obligation. And then he refers to the significance of assumption of responsibility by reference to Lord Rogers' judgment in the Mitchell case, and you'll see that set out there. So the first key criterion or factor identified by Lord Dyson is assumption of responsibility for the individual's welfare and safety, the paradigm example being detention, and detention in whatever the setting might be. Now, my lords, my lady, essentially, in relation to whether an operational obligation was owed to Ms Maguire, and assuming that there's an arguable case in terms of real and immediate risk, that's the beginning and end of the position. Ms Maguire's circumstances fall precisely within what Lord Dyson is here describing. There's been an assumption of responsibility by the state for her welfare and safety, including by the exercise of control. She is the paradigm example. She was deprived of her liberty for perfectly benign and proper reasons, as indeed will a patient detained under the Mental Health Act be. Lord Dyson then continues, however, paragraph 23, to identify certain other factors teased out of the case law. The next factor in paragraph 23 is vulnerability as a relevant consideration. In circumstances of sufficient vulnerability, so this is paragraph 23, letter D, the ECA, the European Court of Human Rights, has been prepared to find a breach of the operational duty even where there is no assumption of control by the state, such as where a local authority fails to exercise its powers to protect a child who, to its knowledge, is at risk of abuse, as in Z and the UK. It's not relevant for present purposes that this was a complaint of breach of Article 3 rather than Article 2. So we have there the three factors I identified at the outset of my submissions: deprivation of liberty, assumption of responsibility, vulnerability. Paragraph 24, Lord Dyson identifies another factor which is not in my submission particularly material for present purposes: nature of the risk. And that reflects what was a fairly unusual case about a death through parachuting of a soldier on military exercises in Stoyanovi, and he refers to that in paragraph 24. Paragraph 25, all of these factors may be relevant in determining whether the operational duty exists in any given circumstances, but they do not necessarily provide a sure guide as to whether an operational duty will be found by the European Court to exist in circumstances which have not yet been considered by the Court. And then he goes on to talk about how the growth of the case law is incremental, boundaries still being explored, and then he says, last sentence on the page, seems to me the Court has been tending to expand the categories of circumstances in which the operational duty will be found to exist. And then if we go over the page, he comes to the central question essentially the same argument in Raybone had been deployed previously in Savage. This is a healthcare case, so the operational duty is not engaged. And that's rejected by Lord Dyson, just as it had been rejected by the House of Lords in Savage. And then he discusses the differences between psychiatric and detained and voluntary psychiatric patients, paragraphs 26 through to 27. And paragraph 28 suggests that these are in many ways more apparent than real. And this was an important part of his reasoning, obviously, because Ms Raybone was not, unlike Ms Maguire, someone who was deprived of her liberty. But there's reference there to the statutory powers, and this is between G and H, being the means by which the hospital is able to protect the psychiatric patient. And of course, it's the exercise of statutory powers under the Mental Capacity Act, which is the means by which the authorities are able to protect the position of someone such as Ms Maguire. And so his conclusion is paragraph 33, having set out a number of other matters, including reference to the Savage case, bottom of page 2437. As I've said, the European Court's not considered whether an operational duty exists to protect against the risk of suicide by informal psychiatric patients, but the Strasbourg jurisprudence shows that there is such a duty to protect persons from a real and immediate risk of suicide, at least where they're under the control of the state. And then he poses the question, on which side of the line does someone such as Ms Raybone fall, paragraph 34, and answers it that she falls on the side of the line, which means the operational obligation, the real and immediate risk Osmond formulation, applied to her situation. There's likewise, as with Savage, there's a concurring judgment from Lady Hale, which starts on page 2451. I don't propose to take you to any particular part of it, but it is again, worth reading the judgments in full. And it's then several years later that Strasbourg, as it were, caught up with this court by reaching the same conclusion as the Supreme Court had reached in Raybone, but in the case of Fernandes de Oliveira in Portugal, where, again, with a particular emphasis on vulnerability, which we see in paragraph 124, page 2673, the Strasbourg court held that the operational duty did apply to informal, i.e. non-detained psychiatric patients. So if we pause there in terms of the case law, I would make the following short submissions. Firstly, the operational duty is plainly not limited to suicide or intentional harm from third parties, and it's plainly capable of arising where the issue is the provision or non-provision.
Sorry, you're being a little bit fast. I'm having a little bit of difficulty hearing. The operational duty is not limited to suicide or
intentional harm from third parties. It is plainly capable of applying where the issue is the provision or non-provision of care and treatment. Secondly, the operational duty has consistently been held to apply in contexts where the person is deprived of their liberty. Indeed, there is no case I can think of or am aware of where it hasn't been held so to apply, given, of course, the real and immediate risk. Thirdly, the key factors in ascertaining when the duty may arise, as identified by the Supreme Court in Raybone, drawing on all the authorities that we've looked at, are vulnerability, assumption of responsibility, and deprivation of liberty. And both assumption of responsibility and deprivation of liberty bring with it ideas of control. Sometimes the case law refers to control. And so, fourthly, we say it's not an extension of the case law to say that the operational obligation can arise in the case of Ms Maguire or others like her, deprived of their liberty, vulnerable, and in the care of the state. Indeed, we would submit that Ms Maguire's is indeed a paradigm case. And the need for protective measures for someone such as Ms Maguire, who cannot themselves secure any assistance for themselves, who cannot voice their symptoms, who cannot insist on medical attention, is at least as great as that of a prisoner or immigration detainee or psychiatric patient, whether detained or not detained. So if we stop the review of the case law at Rainbow and we say the answer is very clear, assuming is to be looked at on its facts, the existence of a credible suggestion of a real and immediate risk of harm, the operational obligation in principle can arise. It's necessary then to look and see whether there are any cases that point in a different direction since the authorities that we've been looking at, and particularly the authority of this court in Rainbow. There are three cases I wanted to refer to. The first is Câmpinu and Romania. That's page 2540. 2540 is where it starts. Decision of the Grand Chamber in 2014. So its full title is the Case of Centre for Legal Resources on behalf of Valentin Câmpinu and Romania. And if the court turns to page 2544, you'll see the deceased's position described in paragraph 7. He was someone with severe learning disabilities, but also someone who was HIV positive. So learning disabilities, but a physical health condition, which is ultimately what led to his death, or the lack of treatment for that is what led to his death. If one turns to the next page, I don't want to, again, read through the facts in detail in the interest of time, but if I draw the court's attention to the narrative set out from paragraph 13 through to...
So, sorry, he's a child in an orphanage, is that right?
No, by the time the events under question are being considered, he's an adult. He had been a child in an orphanage, abandoned at birth.
Right.
But you'll see from paragraph 8, I'm sorry, the dangers of taking things too quickly, he had turned 18 by 2003. So he's a young man. Paragraph 8 on page 2544. And then if we pick matters up from paragraph 13 onwards on page 2545, there are a series of events in February 2004. He's taken to an establishment referred to as the CMSC. They can't adequately deal with his needs. He's then sent to the psychiatric hospital a few days later. That's over the page, paragraph 16. Note that they couldn't obtain his medical history because he wouldn't cooperate. He's then returned to the centre, this is paragraph 17 onwards, transferred back to the hospital, that's page 2547, and these are events taking place over about 3 weeks in February 2004, and then he stopped eating, this is paragraph 22, refused to take his medication, provided with an intravenous treatment, and then he, paragraph 24, died 20th of February 2004. So, physical health, but ability to access treatment compounded by learning disabilities. Not formally detained. It may well be that, viewed through the prism of the Mental Capacity Act, this is someone who, in equivalent circumstances in in the United Kingdom would have to be subject to a deprivation of liberty authorisation. But he wasn't formally detained in any event. The court's assessment then starts on page 2589. Again, inevitably, I'm going to end up taking this quite quickly, and it may merit more detailed reading. But we see the general principles articulated in paragraph 130, page 2589, the bottom of the page we see the operational duty formulation. So the positive obligations where there's a real and immediate risk they're referred to. And if the court goes over the page to paragraph 131, page 2590, pick it up at 4 lines into the paragraph 131, persons in custody in a vulnerable position, authorities under a duty to protect them, and so on. And then there's reference to a range of authorities, which we haven't particularly looked at, but I don't think we need to. And there is then well, in fact, perhaps I should just flag up the sentence in paragraph 131, 5 lines down.
Yeah. Where
the authorities decide to place and maintain in detention a person with disabilities, they should demonstrate special care in guaranteeing such conditions as correspond to any special needs resulting from his disability. And then more broadly, the court has held states have an obligation to take particular measures to provide effective treatment of vulnerable persons from ill treatment of which the authorities had or ought to have knowledge. And then there is a discussion...
I'm sorry. It's partly because of that way of putting it that I was wondering whether one might, in relation to a person who's vulnerable and or in detention, say that the obligation under the Osman principle more generally becomes more intensive, almost as a way... perhaps misstated it slightly by saying that one reduces the trigger conditions of working out when is there a real and immediate risk. But I wonder whether it doesn't actually come down to that it's where the state knows that there are special needs, that they ought to be being more proactive than would otherwise be the case, which seems to imply that it's not necessarily the same intensity of real and immediate risk which triggers the obligation, but something less than that, which the state ought to be looking out for.
Yes, that may indeed reconcile what otherwise might appear to be the tension in the 2 lines of cases, my lord.
Right, thank you.
But it's also a question of protecting them from what? I mean, I can quite see that someone in Miss Maguire's position, and you've taken us through the authorities, and you say she's clearly in the category of people who need to be protected, for example, from the risk of committing suicide if there's a real and immediate risk of her doing that, or of being attacked by other residents in the home. But what is it that is the content of the obligation once she's in a class of people to whom the obligation is owed, when it's not either of those 2 things, it's a risk of her dying from illness? Now, I don't think you'd go so far as to say they have an obligation to prevent her from dying of illness. So what is the obligation to protect her from? How would you express that?
It's an obligation to, and there are 2 ways of putting it. The first way, and using as closely as I can the terminology of the Osman line of authorities, it's an obligation to take measures to reduce the risk of her dying from a physical condition, a serious physical condition, which they clearly, whether it's the full height of the Osman obligation or otherwise, they must have some reason to understand that she is at risk from that condition. And this is, the case we're looking at is such a case because it's a failure to ensure proper treatment and care of someone who was HIV positive and physically frail. Yes.
And what's the second way of putting it?
The second way of putting it is to look at it more straightforwardly in the Terrarieva and other authorities' sense of, and the way in which Article 3 cases evaluate the position of those who are detained, and to say a failure to provide adequate treatment or care. But again, there would have to be some circumstances which would identify the need for such treatment or care. So whether the two are really distinct ways of looking at it, or ultimately come to the same thing, may ultimately be a moot point, at least for my purposes, in establishing an arguable breach and thus a procedural obligation. There's then, in relation to this judgment, a detailed discussion, page 2591 onwards. I won't take the court's time going through it, but there's discussion of how he was transferred without proper assessment of his needs, and how essentially his health and care needs were not met in this critical period in the course of February 2004 in particular. And so a breach described as in paragraph 144 on page 2594, a breach by not providing the requisite standard of protection for Mr. Campineau's life. So that's one of the authorities that postdates Rayburn, and in my respect, the submission is entirely consistent in terms of direction of travel with all the submissions I've made so far. The second authority, which I will try and take quickly, is the case of Nencheva and Bulgaria, page 2884. This is the English translation. The original French judgment appears in the preceding pages of the bundle. And if we go to page 2887...
Sorry, just on that. This is a formal judgment of the court, isn't it? It looks like it.
I may need to check as to whether...
It's got the logo and everything.
Yeah.
else. I'm not sure why you're saying there's a French version. This is authoritative, not just a translation.
I think it may be, I may need to check, that this has been translated for the purposes of this case.
It doesn't look like it.
I know, I appreciate that. I don't know how the translation's been done, but they've used the same format and font.
I can tell you in a moment.
The French, and that's my understanding, and that's the reason why we put in the French judgment, which starts on page 2835.
Wow.
I've just asked the question of how we have
It's curious. Yeah, on the court's website, it doesn't appear in English. It's in 6 languages, including French, but not English. And yet it has all the appearance of an official translation.
Yes, I don't think it is. It has been translated, as I understand it, for the purpose of this case. I will find out translated by whom.
Yes. Because
I don't know the answer to that, I'm afraid, off the top of my head. I don't believe anything will turn on it, and my A-level French may permit me to analyse the judgment in terms of the relevant passages and check that there's no...
and I'm so sorry, you did tell us the page for the French version.
Yes, the French version starts on page 2835.
Thank you.
There isn't anything that particularly turns on nuance of wording in this case, so I hope it's not a problem. The facts of the case are at pages 2886 to 2887. So children with a range of mental disorders, some with physical disabilities, placed in a shelter, so-called a home, in core conditions. And then if you go to page 2891, there is a description of the particular problems that then ensued during the winter of 96 to 97, which essentially led to, over the page 2892, a range of problems for the home, inadequate food, difficulties with hygiene, difficulties in relation to heating. A number of the children died. 7 of the children, 15 children died, and the case concerned 7 of those 15 children, children and young adults, I should have said. So obviously a very serious case on its own facts. But just if we go to page 2913, so start on page 2912. We have the general principles articulated on page 2912, and then on page 2913 we then have the articulation of the operational obligation. And then if we turn to page 2915, paragraph 118, you will see that a case is examined by means of the operational obligation. And we can see that squarely from page 118. Should have known there was a real risk and didn't take measures which from a reasonable point of view would have mitigated that risk. And then we see factors there then set out: vulnerability and having been placed in the care of the state. And then over the page, the dreadful living conditions then set out. And that found the conclusion that there was a violation of Article 2 because there's been a failure to protect the lives of vulnerable children in the care of the state. And that's paragraph 141, page 2922. So again, in terms of the duty arising, it's vulnerability in the care of the state, unsurprising given the fact that a breach is then found. The final case, in terms of the general principles that I need to...
Well, they're vulnerable in the care of the state, and the breach is of a duty to protect those children to a certain degree, which was clearly breached in this case. But I don't think you can just jump, or I didn't understand you to be saying you can jump from the fact that these children are vulnerable and in the care of the state, and then they die. Are you saying that that's enough to give rise to a suspected breach of some duty?
Yes, enough, coupled with the fact that the authorities either knew or should have known that their health and lives would be placed in jeopardy because of the conditions in which they were being accommodated and cared for.
That's what where does the extent of the conditions in which they were being held, cared for, how does that fit in to your description of the duty that's owed to them?
It doesn't fit into the description of the duty. It helps explain why it was the authorities on the facts of that case knew or ought to have known of a risk to life. And then obviously it also goes then to the breach of the duty. But the duty itself arises through the combination of vulnerability and care of the state coupled with actual constructive knowledge of risk to life.
Yes, but duty to do what?
To prevent them from dying, to provide adequate care and treatment or adequate facilities so that their lives would not be endangered.
I wonder if that really is right, because, I mean, in the passage you showed us, paragraphs 118 and following, page 2915, the court itself seems to identify factors which are decisive in assessing the responsibility of national authorities. So they seem to be saying that these factors somehow do feed into the Osborne-style obligation which is shown.
Is there any particular paragraph, my Lord?
Yeah, well, paragraph 118 considers that in the face of the applicant's allegations, the authorities failed to protect the children's right to life. It is essential to be satisfied the authorities should have known at the time there was a real risk to the children's lives and that they did not take within the limits of their powers measures which from a reasonable point of view would probably have mitigated that risk. To this end, several factors appear to be decisive. So the factors such as vulnerability, assumption of care and so on this account from the court seem to feed in some way, but we're asking for your assistance as to how, into the extent of the Osborne duty.
First of all, that last sentence in paragraph 118, it's not clear, and again, maybe worth me looking at the French original. It's not clear whether that is saying that what follows is going to be decisive in determining if there's a duty or decisive in determining whether there's a duty and a breach. But then in terms of
sorry, why does the difference matter?
My Lord, because the first question with which I'm grappling with and addressing the court is the circumstances in which an operational obligation may arise, and then the next question is whether there has on the facts been a breach of that.
Well, no, there must be an intermediate step as to what is the duty. The duty arises in respect of certain people. The duty, one might say, paraphrasing paragraph 118, is a duty in circumstances where the authorities know that there is a real risk to the children's lives, to take, within the limits of their powers, measures which, from a reasonable point of view, would have mitigated that risk. That seems to be what the court there is saying is the content of the duty which was owed to these children. And then you have to say, on the facts of this, was there a breach? Did they not take measures which, from a reasonable point of view, would have mitigated that risk? But it seems to me that in your formulations, you miss out what seems to me an important thing, which is the content of the duty, in addition to preventing people from committing suicide, preventing them from being killed by other people there. It's taking measures from a reasonable point of view to mitigate the risk of them dying.
And Melis's absolutely right, and that's in all the formulations from Osborne onwards. What's articulated is that the duty, if it's triggered, is a duty then to take appropriate, reasonable, protective measures to mitigate or reduce that risk.
Right.
That is, Melis's absolutely right, and my Lord, that's obviously part of the duty. What those measures are entirely fact-dependent.
Yeah, but what matters to us is, do those measures include a risk to take reasonable steps to mitigate the risk of somebody dying because of what one might loosely term medical negligence or negligence of the care home staff?
Well, it's not steps to mitigate medical negligence, it's steps to reduce or remove the risk of dying. So it can be anything from, in the context of the psychiatric patient, a proper assessment of their condition, through to taking someone to hospital or monitoring them properly or doing the right tests or giving them the right treatment for their HIV. So that the measures will depend upon the particular facts of the case, always.
one factor that we're told is, in this case, we're told is essential, is that the authorities be is that the court be satisfied that the authorities should have known at the time that there was a real risk to life, which obviously, puts this in the Osman,
Yes.
Osman and Keenan line.
It does.
It's not obvious, I think, that test is met in the present circumstances.
Well, I'll come on to that, if I may, relatively shortly. If I can then just, in terms of case law, take you to Lopez de Sousa Hernandez.
Yeah.
Paragraph 277, sorry, page 2774. So the judgment begins on page 2699, but if we start with the court's assessment on page 2774, paragraph 162 and 163 required to be read together. The court's frequently called upon to rule on complaints alleging a violation of Article 2 in the context of healthcare. A considerable number of these cases concern allegations of negligence occurring in the context of medical treatment in hospitals. In this regard, the court considers the present case provides an opportunity to reaffirm and clarify the scope of the substantive positive obligations of states in such cases. And then we looked earlier at what the court then said in terms of systemic duties. But it's paragraph 163, which I didn't take you to earlier, and which is critical. The court would emphasise at the outset that different considerations arise in certain other contexts, in particular with regards to the medical treatment of persons deprived of their liberty or of particularly vulnerable persons under the care of the state, where the state has direct responsibility for the welfare of these individuals. And the footnote gives us examples: the Slimani, that's the immigration detention case, and the Centre for Legal Resources in Romania. That's the...
And did both of those cases have, as a constituent element, the real and immediate risk? Salami and...
Slimani, it's not entirely easy to say that from the decision, which, as I recall, resulted in a finding of no breach. I'll have to check that, my lord. Centre for Legal Resources in Romania, what was, I think, properly understood on those terms?
Sorry, was or was not?
So the Centre for Legal Resources in Romania is a real and immediate risk case.
And just on that, I thought in answer to an earlier question by Lord Stevens, you accept that real and immediate risk is part of the operational duty test that we should apply in this case.
Our submissions are twofold. Our primary submission is that is the case. And that appears to us to be the more conventional reading of the authorities.
Right.
Our secondary submission in our written case is that there is the line of authorities, Terrara-Yeva and others, which doesn't appear to require the real and immediate risk in those stringent terms, but looks at the inadequacy of the care or treatment that's provided. And my lord earlier posed a
so you're maintaining both arguments under both heads, both limbs?
Yes, but I would recognise that it may be that the answer is essentially the answer my lord formulated earlier, that there's less of a difference between those two than might be thought. And it may be that it's in the context of the secondary line of cases, that the stringency of what's required in terms of real and immediate risk is somehow softened.
Right, yes.
And that may be a way of reconciling them. But our primary case absolutely is real and immediate risk and always has been. Simply, we recognise there's another way of looking at the authorities. And both sets of interveners focus on that second way of looking at the authorities, which is why it seemed important to tease that out as well. So paragraph 163, then just the last sentence: such circumstances are not an issue in the present case. And the court then goes on to give the exposition it did, culminating in a discussion of the systemic principles. And we looked at paragraphs 186 through to 189 of the judgment. But the key point about Lopez is it's got nothing to do with the issues that we're concerned with, as the Grand Chamber expressly recognised in paragraph 163.
And that's the point that a Court of Appeal seemed to have missed.
Yes. And that's where, with the greatest of respect, the coroner then went wrong. Lopez is followed by the courts.
But I don't quite see how that works. You have a prisoner, he suddenly becomes terribly ill, he's sent to a hospital, and the hospital treats him negligently and he dies. I don't see that the state can be responsible for that negligent treatment on the part of the hospital doctor. Just because he went into that hospital from a prison rather than from his own home. So mustn't the stepping back from making the state responsible for all medical negligence cases have some repercussions for this case? I mean, suppose Miss Maguire had been sent to hospital on the night of February 21st, owing to mess-ups in the hospital, she was then not properly treated. Are you saying that that would then be a breach of the state's duty, even if it wouldn't have been, if she had been not in the state's care?
That is precisely what the authorities say, my lady. That's not this case, and my lady is posing a hypothetical in relation to what might have happened to Ms. Maguire.
I am posing that because you seem to be saying that we can entirely ignore what Fernandez says about medical negligence because this is a detention case.
Well, I'm saying the Grand Chamber says that, my lady, not me saying that. So the Grand Chamber says in terms, and using the terminology of medical treatment, that different considerations arise and those circumstances are not an issue in the present case.
But that's a little bit different from saying that just because it's a detention case, the state is made the guarantor of the standard of treatment provided by an ordinary hospital. I mean, the Grand Chamber isn't saying that. They, in effect, just put that question to one side.
My Lord, I don't want to be seen to be ducking the question, but I hesitate to answer a scenario which goes rather further than the circumstances with which this case and those whom I represent are concerned, where what we're talking about, and this is what I think we'll be talking about in most of the classic prisons and detention cases, is the fact that the individual doesn't get to access that care and treatment. And that's the critical point here. Whether different arguments could arise if the moment Ms Maguire asked to see a doctor, she'd been taken to hospital, and none of the failings on the 20th through to the 22nd, early morning on the 22nd of February had occurred, is a different case from the case I'm advancing. I understand why the court asks the questions it does. The case law certainly may point to an answer, which is that when you look at, and I keep going back to Terrarieva, one goes back to Terrarieva, it effectively fixes the state with responsibility, both for what happens in terms of the adequacy of the provision that's made within the prison and the adequacy of the provision that's made in the public hospital. It may be because that couldn't essentially realistically be untangled. But I don't go that far in this case because there's no need for me to go that far. The whole problem here is that she was never given the access, we say sufficiently timelessly, to the treatment that someone who is not vulnerable and detained could access for themselves or whose family could assist them to access.
But I'm not sure that's a very clear line. I mean, it may be that we have to operate with something like that because of the Strasbourg case law. But in this case, various people made mistakes. Some of them are independent medical practitioners. And it's partly due to their mistakes that Ms Maguire is not taken to the hospital. But you can imagine that at a hospital, errors might be made, which means that she was not given appropriate treatment at that point, and so in that sense is not given access to treatment. I mean, there is a relationship between the involvement of medical professionals making mistakes and a person not getting the treatment they require in very many cases. And I'm not sure that just saying, well, she wasn't taken to hospital allows us to say, well, that's a clear dividing line, it must be a different sort of case.
Well, if one looks at it from the perspective of what the Convention is about, the Convention is about, in part, in this context, imposing protective obligations on the state when they take someone into either their custody or their control. That obligation may often arise because it's designed to address a position of inferiority or deficient access compared to the general population. The fact that one could theoretically identify cases in which it might secure a greater access doesn't really detract from the fact that that's the nature of the obligation. If we go back to the suicide cases, the obligation that was owed to Ms. Raybone in terms of the steps that could or should have been taken to prevent her from hanging herself in the park on home leave arose because of the relationship that existed between Ms. Raybone and the hospital. She had been taken into their care, and therefore they had an obligation to do things that might prevent the risk materialising.
I think the point being put to you is perhaps a more limited one. What's said in 163 seems, at least to me, to be perfectly reasonable, that if you have persons who are deprived of liberty or people who are particularly vulnerable, then there are different considerations which arise in relation to their medical treatment as a generality from the medical treatment of people who are neither deprived of their liberty nor vulnerable. But the different considerations arise by virtue of their being deprived of their liberty, by virtue of their being vulnerable, and try to address those potential problems in their accessing adequate medical care. But that isn't to say that Article 2 applies differently to those individuals if there is a deficiency in their health care which is completely unrelated to the fact that they were vulnerable or deprived of their liberty. If they were simply given the wrong prescription, perhaps, or administered the wrong medication by a nurse through sheer carelessness, and it's got nothing to do with their vulnerability or their status as a prisoner or whatever it might be.
Yes, and that does, I hope, reflect the way in which we seek to put this case. It's very much focused upon, as it were, why it was Ms. Maguire was in the care of the state, and what it was that the state should then be doing to address the fact that she had these vulnerabilities, they had taken responsibility for her, they deprived her of her liberty, and she couldn't then, she wasn't someone who could access that intervention.
As I understand it, you're trying to distinguish her case from an ordinary case of medical negligence on the basis that the deficiencies in her care were related to her status as a person who was very vulnerable, who lacked mental competence and was deprived of her liberty.
Yes. And just to go back to the example I was trying to give by reference to Raybone, it's not precisely on a par with the point that my Lord puts, but this court has held in Raybone clearly the duty that was owed to Miss Raybone because it had taken responsibility for her by admitting her to the psychiatric hospital, albeit she was not sectioned, so they couldn't prevent her from leaving. There may be individuals living at home in the community who go to the GP and whose GP fails to recognise a risk of suicide and take steps to address it. currently, the Convention case law would say that those are different situations. And it's not about saying that the person who lives in the community in their own home and goes to their GP is entitled to a lesser standard of healthcare or a different standard of healthcare. It's about saying what is the obligation imposed upon the state when it decides to actually take people within its arms, within its control. I'm sorry, I'm conscious of the time. Can I then, just having made the submission I made about Lopez, draw to the court's attention, but without taking you to it, the decision of Parkinson. It starts on page 2207 of the bundle. It's essentially a case which then relies upon and summarises domestically Lopez. And it's the case that was relied upon by the coroner in his ruling. Parkinson was not a paragraph 163 of Lopez case, so it wasn't a case about detention, vulnerability, assumption of responsibility. And so, essentially, if I'm right on the submissions I've made so far, Parkinson changed nothing and was erroneously relied upon by the coroner. My Lord, my Lady, can I then just come to, having looked at the authorities and made the submission, which is again set out in our written case, I think at paragraphs 53 and 54, as to why we say this is a case in which there was an obligation, an operational obligation, in principle could arise. I then turn to the second stage of the submissions, which is to say, is there an arguable case or credible suggestion that the state's been in breach of its substantive duty, whether systemic or operational, such as that the procedural obligation arises? And I know I've made the point already, but important to emphasise, we don't have to establish that there was a breach, only that there was an arguable or credible suggestion. By way of background facts, the court already knows Ms Maguire's fear of doctors and medical interventions, knows that she had limited verbal communication, learning disabilities, which meant she would not be able to clearly communicate when things were wrong. A further matter in terms of the factual background.
Sorry, could you just fear of doctors and medical
interventions?
What were the other ones?
And then had limited verbal communication, and because of that and her learning disabilities, could not always clearly communicate when something was wrong. She was also on a medication regime because of her back pain. She was treated with naproxen, and that's medication which it was well recognised, and the evidence before the coroner was clear, increases the risk of a gastric ulcer. So that's something we say is part of the factual picture, could and should have been something that those caring for her should have been aware that she had an enhanced risk, not a huge risk, but enhanced risk above that of the general population in terms of the development of a gastric ulcer. In terms of arguable breaches, I'm not going to take my lords through the details of the facts. I hope you have those sufficiently from the statement of facts and issues and our written case, and indeed from Mr Maguire's written case, which looks at the various different agencies and the steps that could, simply on the evidence before the coroner, where it can readily be said steps could have been taken. So I don't propose to go through those in the interests of time. But in terms of breaches that could be said to be arguable breaches of the systemic obligation, I referred, it seems some hours ago now, in answer to my Lord Stephen's question, to the question of putting in place a protocol or care plan in relation to how to get her to hospital. I won't repeat any of the submissions I've made already in relation to that. A second arguable systemic breach, general breach, was the absence of any system or properly functioning system within the home to ensure a proper recording in relation to Ms Maguire's health, her symptoms and seizures, so that those could be accurately shared. And there are numerous examples of where either one carer knew something but the other carer didn't, or other carers didn't, or a carer knew something but they didn't tell the GP, or the GP didn't elicit it from them, or the NHS 111 knew something but the paramedics didn't, or the paramedics, the carers knew something and the paramedics didn't. So there were a range of problems in relation to the sharing of information, and not just on a minor or trivial sense, but in two key respects in particular. The vomiting blood, a coffee ground vomit, where that information was not centrally collated and therefore shared with all those who then had to take decisions in relation to Ms Maguire. And the timing of the fits. So the timing of the fits. So both the out-of-hours GP, Dr Fairhead, and the paramedic crew who attended in the evening of the 21st of February proceeded on the entirely mistaken belief that Ms Maguire had one fit that day several hours previously, and they expressed a degree of perplexion as to why the ambulance is being called several hours later, whereas as a matter of fact she'd had a fit or faint or seizure, however one might characterise it, at around 7:15 that evening.
In paragraphs 55 to 57, you set out what you say were the systemic failings, and these are statements of propositions of fact. For example, the absence of any effective training in the Mental Capacity Act 2005 amongst care staff, ambulance staff, and the out-of-hours GP. Are these supported by evidence that was led before the coroner?
Everything that we've set out should be supported by evidence. So if there's any that's not got a...
It would be very helpful if you were able to give us references to where we would find...
Yes, absolutely. In relation to...
And so, sorry, are those matters set out in the agreed statement of facts and issues, or...?
Well, they're not agreed systemic failures, so no, they're not set out in the agreed statement of facts and issues.
But you're not asking us to find that there were systemic failures, but you're asking us, I think, to find that there was an arguable basis for a finding by a jury, or at least as a basis for a finding by a jury.
Exactly, a credible suggestion or arguable case. We can certainly, by reference to each of these, just do a document which gives the relevant page references in the bundle. Sometimes we have put them in, but by looking at it, I can see that that's not been consistent, and the court obviously needs that. Yep. So the third, and again, I'm not going through each of these, and again, in the interests of time, the third, in terms of looking at it on a systemic level, it was about decision-making and the powers of decision-making under the Mental Capacity Act. And just perhaps a handful of background documents to refer to. I'll hopefully just give the court the references. So in terms of Mental Capacity Act understanding and documentation, a problem in relation to the home in that regard had been flagged up in a CQC inspection, page 1389. More generally, and if we go back to...
I'm so sorry, the page number again?
1389.
Thank you.
Again, I'll certainly check that, my lord, when I put together the list of page references.
That's a reference to what? I'm sorry.
Care Quality Commission inspection in relation to the home.
So is that a reference against your little c in paragraph 55? Is that the appropriate place to put it?
It is, but I'll draw all the references together, my lords, and I'm sorry not to have done that in advance.
So this is a report of an inspection carried out prior to Miss Maguire's death.
That's correct.
Which found that various requirements were, various improvements were required.
Yes. That's right. And the reference, again, I'll put this in the list of references. Page 1390 specifically talks about the requirements of the Mental Capacity Act and deprivation of liberty safeguards.
Yeah. In your little C, you say there's an absence of a regulatory enforcement mechanism. But, I mean, on my understanding, what happens with CQC inspections is that they identify problems. If the problems are big enough, care home's licence will be taken away, or if they fail to improve, you're nodding. Is that the way it works?
My Lord's absolutely right, and so that is probably slightly clumsily expressed, and it is better expressed as an absence as a defect in the system. That there's the evidence of a defect in the system, although it's then added to by what we know about from the evidence of the individual parents, which I can pull together. Bearing in mind that the systemic obligation can be at both the abstract level and, as we explored this morning, really quite granular levels.
So are you saying that there was a systemic failure because the licence of this home was not taken away as a result of the CQC inspection? No,
I don't think I can put it that high, and hence this is probably better expressed as being the failure is that there was a known deficiency in terms of compliance with an understanding of Mental Capacity Act principles and powers. But can I...
Understanding on behalf of whom?
Of the home.
So what should have happened, do you say?
Well, had there been, specifically in relation to home, had there been a proper and better understanding of the powers conferred by the Mental Capacity Act, the home should have, arguably, done more to ensure that Ms Maguire was taken to hospital. Or...
I can see that it might have been a cause of an operational breach, an arguable operational breach. But I don't at the moment see what... There was a lack of understanding, but I don't see how that's translated into a structural duty or a breach of a structural duty.
Well, it's in this context, it's the structural duty at the less general, less high level, where we start shading in potentially to the operational duty in that respect. But just in relation to the Mental Capacity Act, there's a broader problem in relation, and this was explored at the inquest, and I will give the relevant references to the. In particular, the paramedics' understanding of what it did or didn't permit them to do, and there are parts, and the references I think do appear elsewhere in our written case to this. There is, for example, a submission that's made on behalf of the ambulance service at one stage of the matter, that the Mental Capacity Act effectively rendered it impossible for them to do anything. There is also a limited understanding as to what the powers of the Mental Capacity Act were in terms of, for example, taking steps such as sedation. So a lot of these feed into one another in terms of what the potential systemic breaches are.
So that's a systemic breach by the ambulance services?
Yes.
Right.
Just by way, again, of context, there is evidence, and it's in the what's called the Leader and Sippold reports, of there being broader problems in terms of those with learning disabilities being able to access healthcare, and the excessive number of premature deaths of people with learning disabilities. I wonder if I can give the court the references to those, because I don't think the time will permit me to take you to them. The Leader report appears at page 1052, and the relevant page starts then. The relevant page references at page 1061, which talks about the higher mortality rate for those with learning disabilities, and identifies more than a third of the deaths being looked at within the time frame covered by that report as being deaths that were potentially amenable to healthcare interventions. Sepsis is identified and this is page 1072, in 11% of the medical certificates of cause of death that they were looking at within this cohort of patients. And page 1077 talks about problems of, again on a more general level, of interagency collaboration and communication, particularly in relation to care homes and health professionals' communication. And then page 1079 identifies a broader problem with understanding and application of the Mental Capacity Act. Page 1079. And then there are...
What deals with what? I'm sorry.
A need for better understanding of and application of the Mental Capacity Act.
Thank you.
And then the Sippold report, and that's the Confidential Inquiry into Premature Deaths of People with Learning Disabilities final report, starts on page 1091. Page 1096 identifies women with learning disabilities dying on average 20 years sooner than women in the general population. Page 1099 identifies a common lack of adherence to and understanding of the Mental Capacity Act by health and social care professionals, deficiencies in record keeping being common, and little attention given to predicting potential problems, for example, where a person is fearful of contact with medical professionals. So a broader recognition of precisely the problem in the present case. And also that report identifies that more people with learning disabilities die from causes that are amenable to change by good quality healthcare than people without learning disabilities. And then page 1100 again talks about poor adherence to the Mental Capacity Act. Poor adherence to the Mental Capacity Act. I'm sorry, I'm moving away from the microphone.
We also refer, as I see, to a House of Lords Select Committee report on lack of understanding of the MCA amongst professionals.
Yes,
is there evidence that this was a factor in the present case?
Well, we say that there is evidence it was a factor in the present case because it's having ascertained and there being essentially a common understanding by the evening of the 21st that Ms Maguire needed to go to hospital. There is then not an understanding, we say, a proper understanding of the fact that the Mental Capacity Act plainly empowered, indeed required, Ms Maguire to be taken to hospital if being in hospital was in her best interests. And it was the evidence before the inquest essentially was that it was accepted it was in her best interest to go to hospital.
Right. So again, can you give us a reference?
Absolutely.
To the relevant passage?
My Lord, I will. And the House of Lords Select Committee report.
I've got a reference to that in footnote 43.
Yes, 5685 of the full bundle.
Yeah, I mean, the particular footnote seems to be over-application of the presumption of capacity. Mm-hmm. I didn't think that anyone thought that Ms Maguire had capacity in this case.
Can I respond to that by giving you some of the references in the passages of the evidence, in particular of Miss Ayres, because there are parts of the evidence which essentially suggest that the paramedic approach was, well, if we can't persuade her, we can't do very much. And so the focus then is trying to essentially comply with what they think her wishes are, rather than looking at what was medically in her best interests. That is at least an interpretation that could legitimately be placed on the evidence that was heard by the inquest.
I mean, I rather had the impression that by the time the paramedics are there, they're trying to make an assessment. Is the need to go to hospital so great that we have to do things which might, in other circumstances, be thought to be unduly heavy-handed, either sedate or physically restrain Ms Maguire and take her? And they just weren't persuaded, admittedly on the defective information they had, that the circumstances were such that it was overall in her best interest. I didn't get the impression that any of that was to do with they thought that she had capacity and therefore was the person who could choose and they couldn't act if she didn't agree.
Well, it's perhaps less an application of the presumption of capacity and more a reluctance to go against the expressed wishes of the incapacitated patient that was the problem on the ground.
But that's because if they went against her wishes, they were going to have to do things which, absent a really pressing need to get to hospital, might be regarded as unduly heavy-handed, sedate or physically restrained.
It's difficult to see how sedation would be unduly heavy-handed, and that wasn't the evidence before the inquest. Indeed, the out-of-hours doctor's evidence was, if she'd known what the actual factual position was, if she'd known the clinical observations that the paramedics had recorded, she would have sent a doctor to sedate. The problem was sedation was never actively considered. So it's not a question of they considered it and reached a balanced best interest decision that the disadvantages of sedation outweighed the advantages of getting Ms Maguire to hospital. That simply wasn't the position on the facts. Of course, there could be different cases where that is the position. In terms of operational obligations, can I just flag up, without taking my lords and my lady to, the approach of the Supreme Court in Raybone to the existence of real and immediate risk. The relevant passages, no need to go to them. It's paragraph 38 and it's paragraph 39 of Raybone, page 2439, where Lord Dyson says a real risk is one that's significant and not remote or fanciful. And in Raybone, a risk that was 5% on the day Miss Raybone left hospital, 10% the next day, 20% by the 21st of April, was a low to moderate risk, but nonetheless a significant one. So it was real for the purposes of the operational obligation. Immediate meant, said Lord Dyson, present and continuing. And may I apologise, because in our written case, I've attributed that to Lord Carswell's speech in Van Colley, and it's actually Lord Carswell's speech in INRI Officer L. But the correct position is accurately set out in Lord Dyson's judgment in Raybone at paragraph 39.
Your turn was drawing on what Mr Justice Weatherup said.
Yes.
In an earlier case.
So in terms of evidence, and bearing in mind again, this is talking about was there an arguable case or credible suggestion of a real and immediate risk, whether in the full Osmond sense or somehow tempered because of Ms Maguire's special needs. As I've indicated, she was at medication that put her on at the risk of a gastric ulcer. There was coffee ground vomit, which meant internal bleeding. She was complaining of severe stomach pains, terrible pains, and there were the episodes of fitting or fainting, which were entirely uncharacteristic. They are not things that have been observed in relation to Miss Maguire previously. Those were all indications that, at least arguably, that something was untoward and something potentially seriously wrong in terms of Miss Maguire's presentation. And in the medical evidence that the inquest heard indicated that it may be that the ulcer had perforated on or by the 21st. In terms of the sepsis, she was on the sepsis pathway. The best estimate that could be given was there may have been a mortality rate, and this obviously was based upon general population data, but a mortality rate of 30 to 40% on the evening of the 21st. It would have been less earlier in the day, and then by the time she's taken to hospital on the next morning, probably in the region of a 70% mortality rate. So we say clear evidence that at least arguably that the trigger of real and immediate risk could be satisfied. And that if something had been done earlier, it could have made a difference because she would have started to receive the treatment for the sepsis in hospital at an earlier stage and before she was in the 70%.
But as far as the real and immediate risk element is concerned, is it enough that there was arguably a real and immediate risk if that is part of the test when the duty arises rather than whether there has been a breach? The arguability threshold relates to the possible breach of the duty rather than the existence of the duty, doesn't it?
Well, the question was never asked by the coroner because having conducted the wider scope inquest, he then on the 29th of June 2018, I hope I have that date right, formed the view based upon the decision in Parkinson, which in turn drew on Lopez, that this was a healthcare case and that you couldn't have an Article 2 breach unless it fell within essentially the circumstances identified in the main body of the Lopez judgment. So you had to have a high-level systemic breach or a case of an exceptional denial of emergency treatment. So the coroner never posed the question, was there a real and immediate risk for Osmond purposes, because he proceeded upon the basis that there was no operational obligation. Because as a matter of law that was excluded, rather than because on the facts it didn't arise. And so it being part of our case to say that was the wrong approach, it would clearly be a fairly pointless argument for me to advance if I, purely in the abstract, without actually saying there is material to think that had the coroner properly approached this, correctly identified himself by reference to the law, that the matter would have been left to the jury. So that's the way in which I approach it, my lady.
Does the arguability apply both to breach and also to the existence of the duty?
Well,
I just thought there was some authority in relation to that, and I was just trying to...
Yes, I may need to think about that, my lord, and answer it overnight. In relation to real and immediate risk, I would tentatively suggest that the arguability threshold does apply, because the coroner, at the point at which he's deciding what to leave to the jury, is not himself the decision maker. He's not the fact finder. The fact finder is the jury. So his task is to ask himself, not as a matter of fact, was there a real immediate risk, but is the material upon which a jury could assess that there were steps that should have been taken in response to the presenting risks.
But it can't be for the jury to decide whether this is an Article 2 case or not. That must be something for the coroner to decide.
The jury doesn't decide if there is a breach of Article 2, nor does the coroner decide if there's a breach of Article 2, because there is no finding, there is no entitlement to make findings that would amount to a finding of civil liability.
Who decides whether this is a Section 5.2 case?
The coroner decides.
Yes.
And the trigger for the procedural obligation arising is a credible suggestion or arguable case that there was a breach of the duty. So that there are matters that properly need to be left to the jury in order for the state viewed as a whole to discharge its Article 2 investigative obligation. My lords, my lady, I'm not going to go through, because I simply don't, I'm afraid, have the time to go through the different factual stages and factual findings. But as I say, Mr. Maguire's statement of case very usefully articulates a number of the key factual areas where it could be said that there was an arguable breach.
But you have indented for quite a generous reply time, so
yes.
It's up to you if you want to eat into that in order to complete your submissions at this stage.
And if I need to in relation to the facts, I will do so then, rather than take up more time now. Can I then just deal with...
Well, sorry, just on that. I think it might be better if it's dealt with in opening, if you've got factual points to make, because then if there is to be a response on them, it can take place at the proper time. Yeah.
Yes, the factual points essentially are those that are made in the written case and in the case of Mr. Maguire, which is why there are points I could emphasise, but they're not new points that we haven't already made in writing. They focus on the period from the 20th February 2017, when Ms Maguire first asks to see a doctor and no one acts on that request, through to the events of the 21st of February, which we've detailed.
Well, the trouble is, it isn't. I mean, you've set out the events, and we have those. But if you're making, for example, a case of systemic shortcoming, then we need to have an analysis of the evidence that bears on the existence of a systemic shortcoming.
So, in our written case, we've given a number of examples in paragraph 62. So in the key documents bundle, it's page 52.
62 is concerned with operational.
Yes, and that's what I was addressing the court on, the operational duty.
But I mean, this is expressed to be by way of example only. I mean, we need to understand your whole case if there's anything to be added to this.
Yeah.
If you read this with Mr Maguire's written case, you essentially have as full a factual picture as you will need, because, again, we haven't gone through every single factual point that could be made in relation to demonstrating a breach of the operational obligation, because this court's role is not to make a finding of breach, it's to identify if there is a credible suggestion or arguable case of a breach. And so, if we're right about that, this court wouldn't be deciding exactly what issues were left to a jury. That would go back to the coroner if there's a fresh inquest. So we need to only identify, for our purposes, some key breaches, we say, or arguable breaches of the operational obligation, and that's what we've decided to do.
If I just give you one example, footnote 46 on page 50 says that the evidence and submissions on behalf of the ambulance service at the inquest were that admitting Jackie was virtually impossible given constraints imposed upon them by the Mental Capacity Act. This was plainly wrong, it said. Now, well, I don't know if it was plainly wrong. If what was being referred to was the need for an assessment that it was in the individual's best interests to go to hospital, well, it's not so obvious that it's not obvious that was wrong. But if, on the other hand, they're referring to some misunderstanding of the legislation, then it might be relevant. But without seeing the context, one can't really tell.
Yes, and the difficulty, obviously, within the limits of time is taking you through all the factual material.
Yes, so that's why, I mean, I appreciate it might take another day to go through the evidence, but at least it would be helpful, rather than doing the analysis completely unaided, to have an analysis of the evidence provided to us, and no doubt provided also, in particular, to Mr. Beer, so that he can make any comments that he has to make on it.
Well, and I'm very happy to do that. In the court's hands as to how best to do it. We can produce something overnight in writing for the court.
It may not be practical to do it overnight. I mean, if, for example, we were to give you 7 days,
yes,
and Mr. Beer another 7 days after that to respond, would that be a realistic way of...
That would be an entirely realistic way of giving the court all the references that it would need in order to be able to fairly assess the what's said to be the credible suggestion of breach.
Yes.
I mean, if I may say, not just the references, we need some sort of analysis of how particular evidential points that you are making feed into the analysis that you've been helpfully giving us today.
Very, very happy to do so, my Lord, yes.
Perhaps I just have a word with Mr. Beer about this. At the moment, it looks as though we do need something like this if we're going to carry out the exercise that we're being invited to carry out.
Yes, one of the points that I might have made tomorrow was that the allegations of systemic breach or of operational breach are very different from the two that were put before the coroner.
Right.
There were only two put before the coroner, both said to be systemic breaches. The exercise that's being undertaken now is to go through, I suspect, transcripts and pull out of a transcript some evidence that might be said to support a systemic breach or an operational breach that wasn't advanced before the coroner. That's slightly problematic from our point of view. Although I think, in the position that we adopt, would be willing to identify any evidence that goes to the points raised by Ms. Richards, I think it would be beyond the scope of our role to engage in analysis of what they mean.
Yes.
I know that might be unhelpful.
No, I quite understand the role that these aren't really adversarial proceedings.
No, and I'd want to try and respect the self-denying ordinance.
Yes. Well,
Look, might I just make one observation in response to that? In relation to the operational obligation, of course, counsel representing the families didn't map out suggested breaches of the operational obligation because the coroner had ruled that Parkinson, based on Lopez, meant that Article 2 could only be engaged in this case in the systemic or exceptional denial of life-saving treatment scenarios. So counsel for the family would not have addressed the operational obligation because the coroner had already, erroneously we say, on the law said that's not something that can go any further.
Sorry, I thought that there had been argument before the coroner leading to a provisional ruling from him that this was an Article 2 case, and then Parkinson comes along. So if that's right, presumably some case had been put forward by the family as to explain why it was an Article 2 case.
Yes, but that's obviously before any of the evidence is heard and at a time when much of the evidence hadn't even been received. So there's the coroner, my lord is right, identified that there was that he was going to regard this as a case falling within Article 2, and in part, as I recall, relied upon Raybone. And then at the conclusion of the evidence said, no, it's a healthcare case, it's a Parkinson case. It's only systematic breaches as understood in Lopez or emergency denial of healthcare. So there was never an opportunity to address the coroner on the evidence about operational breaches. The other point is of course, these are not adversarial proceedings, and it's not the role of the family or those representing the family to have to identify all the material for the coroner. The coroner has an inquisitorial jurisdiction. But of course, in relation to the operational breach, again, never went through that process following the evidence. Many of these matters that I'm referring to were explored in the course of the evidence, but there was never the point at which there was an opportunity then to make submissions, save, as it were, on the hoof in response to the coroner's ruling on Parkinson.
just give us a moment. She set out what her allegations are in the case, but she hasn't given us any guidance as to where we find. No. No, quite. And yes. Well, we would welcome an analysis of the evidence directed to the points that are effectively bullet points in your written case, but expanded with reference to the evidence supporting them. And it may be the 7 days is a bit short. If you wanted 14 days, that wouldn't be a problem.
If it makes no difference to the court, may I ask for 14 days? That would be appreciated.
Yes, very well. And then we appreciate the position that the coroner is in. So we'll leave it to you, Mr. Beer, to make an assessment yourself of whether you want to put in anything in response when you've seen what has been produced by counsel for Mrs. Maguire.
Yes, and would it be impertinent to ask if that facility is taken up, I could have the 14 days too?
Yes, yes. We can do that.
Grateful.
No.
Lords, I note the time and I'm supposed to have finished by now. The one area I haven't addressed the court on that I might need to is where the Court of Appeal went wrong. However, essentially most of that flows from all the submissions I've made to date. The one area I haven't addressed the court on is simply the authority of Dumpe and Latvia.
Yes, well, we do need to hear about that.
If perhaps I could do that, and it shouldn't take me more than a few minutes in the morning.
Yes.
Because that's something which I should address before Mr. Beer makes his submissions. And the second point I should address before Mr. Beer makes his submissions, I think anything else is reply, is just the case for a fresh inquest, if we're right on the law. Because obviously that's something Mr. Beer might want to make submissions on.
Yes. Very well. Well, in that case, we'll adjourn now until 10:30 tomorrow morning, and we'll hear you on these sort of sweeping up issues. The Dumper case is quite important. And then I think we'll hear Mr. Maguire, and then we'll turn to Mr. Beer. Fine. Thank you very much.